Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, okay, and so far we have discussed so many rights, okay, and basically in the previous lecture we had started the discussion over the right to religion, okay, and basically I have told you that in right to religion we have the 4 articles. "25, 26, 27, 28. All right, and basically we have done with the article 25 in the previous lecture. In 25 we had discussed about the 4 principles of implications under article 25. So now you are required to tell me that what were those 4 principles or the implications. This is a question for you and you have you can say you have 30 seconds to think about it, then I will give you the answer. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So basically if we talk about it, first was right to conscience, okay, thereafter right to profess, thereafter right to practice, and thereafter right to propagate. Okay, so if we talk about the first one, right to conscience, we know that basically every individual is free, all right, to you can say do whatever he wants to do to get connected with the God. Right to profess means that any person, he or she, could openly and freely speak about his religion and his beliefs. Right to practice, if he want to do some rituals, then he could do it. And thereafter right to propagate, like if he want to propagate his religion, then he is allowed to do it. So these are the things that we had discussed in the previous lecture. I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture. As many times I have told you, that is for your own benefit. So let's start with the new one. So freedom of manage religious affairs. Okay, this is basically empowered by Article 26. Okay, so according to Article 26, every religious denomination or any of its section shall have the following rights. Okay, the first right promised under this one is right to establish and maintain the institutions for the religious and the charitable purpose. Okay, thereafter right to manage its own affairs in the matter of religion. Thereafter right to own and acquire movable and immovable property. Thereafter right to administer such property in accordance with the law. Okay, like if we talk about religious denomination, all right, so it is a any particular denomination which having the religious nature, and any of its section basically allowed as per the article 26 to exercise any of the things under these rights. Like first they could you can say establish the institutions, even manage it for the religious and the charitable purposes. Thereafter, if they want to maintain their own affairs, okay, then they could do it once it's a matter of religion. Okay, thereafter they could own and acquire the movable and immovable property, and they could administer such property accordance with law. Okay, so these are the things basically they have. Now article 25 guarantees right of individuals, while article 26 guarantees the right of religious denomination or their section. It means that this is having the individualistic approach, okay, and this is having the religious or group approach. Okay, so basically in other words, if you look at here, article 26 protects collective freedom of religion. It means that instead of protecting the individual's freedom of religion, they you can say protects the denomination's freedom of religion. All right, like the rights under article 25, the rights under article 26 are also subject to the restrictions on the public order, morality, health, but not subject to the other provisions relating to the fundamental rights. Okay, thereafter the Supreme Court held that our religious denomination must satisfy three conditions. Like if any group wants to get the recognition under the religious denomination, so basically there are some conditions, or you can say there are three conditions as per the Supreme Court. If the particular group satisfy these three conditions, then only the group will be declared as a religious denomination group. Okay, so the first thing is that it should be a collection of individuals, okay, who have a system of beliefs like doctrines which they regard as conducive to their spiritual well-being. Okay, thereafter it should have a common organization. All right, it means that the group must be homogeneous. If the group having the heterogeneous beliefs, okay, then what will happen? The group will not be recognized under the religious denomination. All right, thereafter it should be designated by a district name. Okay, it means that no religious denomination could have same or similar name. All right, but under the above criteria, the Supreme Court held that the Ramakrishna Mission and the Anand Marg are religious denomination within the Hindu religion. It also held that Aurobindo Society is not a religious denomination. Why? Because it's having the different objective behind the establishment. Okay, After this, now we have the another one is the freedom from taxation for promotion of a religion. Article 27. Like in the previous lecture also, when we were discussing about the when we were discussing about the historical aspects, right? So I had told you several things. Like first, whatever the religion of ruler and his nobles, they basically try to force the same religion on the people of their kingdom. Okay, but if somehow the people is not ready to adopt that particular religion, then what they usually do, that they surpass it and basically allow some individuals to follow their own religion, but made it compulsory to pay taxes to the ruler. Like if the person is not getting converted into some particular religion, which is a religion of ruler and his nobles, then the ruler will impose some taxes on that individuals, and if the individual is paying taxes, then only the individual is allowed to keep his religion. And the most famous example of this is a jizya tax. Okay, the jizya tax was basically, you can say, introduced during the medieval times, when in India there is a Muslim dynasty rules, and the Muslim rulers generally impose the jizya on non-Muslims. If the non-Muslims paying the jizya tax, then the non-Muslims were allowed to do their religious practices in the territory. All right. So these are the things. But when we got independence, basically the first thing we did, we abolish any of the provision. Why? Because if we talk about the state or government of nation, then the one thing which we know is very much clear, that basically Indian state or governor, you can say nation, having no religion. Okay, it means that India is a purely a secular country. So if India is a secular country, the state or you can say the body which governing the India having no religion, so there is no sense to impose the any religion on the individuals, and thus there is no sense to make individuals to pay taxes for the promotion of that particular religion. Got it? That's the thing. So as I have told you, that is basically promised by the articles 27. So it lays down that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination, as the system we had in the medieval times. Okay. Thereafter, in other words, the state should not spend the public money collected by way of taxes for the promotion or maintenance of any particular region. Like if we talk about the income of government, then we know basically it's generated by the two main sources: income by tax, or so known as tax revenue. Okay. Second way is income by non-tax, also known as non-tax revenue. Okay. So basically, if we talk about that particular thing, income by tax or the tax revenue, so who is paying this? This is basically paying by the general people of the country. Okay. And they are paying taxes so that the government could imply, you can say, spend it on the welfare of people and development of nation. Right? That's the thing. So here there is a provision that the state or the government should not spend the public money which has been collected by the way of taxes. Why? Because that money was not collected for the promotion of any particular religion, but was collected for two main purposes: welfare of people. Second is national development. Okay, this is the thing. This provision prohibits a state from favoring, patronizing, and supporting one religion over other. All right. Why? Because if we talk about India, then the Indian state having no religion and thus it is secular, which means that all religions are equal. All religions are equal and thus no privileges granted. All right. This means that the taxes can be used for the promotion or maintenance of all religions. Okay. It means that if the government having some trust, like government also, you can say donates money to some religious trust and all. Okay. But that money which has been granted to the trust or the religious trust for the maintenance of the religion, this must not be given to the any particular religion, and this must be given to the all religions on the equality basis. All right. But this provision prohibits only levy of a taxes, not a fee. It means that if we talk about this provision, then this provision saying that no person required to taxes for any religion, right? That is written down here, but there is no mention of fee. Okay, so basically if we talk about fee, so fee is basically, you can say, a chargeable amount for the services of the state in maintenance. Like if we talk about any religious, you can say, place and all, so many times you have seen that there are security personals, there are police personals and all, they stand there. So under whom these personals comes? These personals comes under the government, and if they have been deployed there for the safety and the security of the pilgrimages, so basically the state is giving their services. Even if we talk about the electricity and all, so this is basically given by the state or the government. So that's why the government becomes entitled to charge the fee, not the taxes. This is because the purpose of a fee is to control the secular administration of religious institutions and not to promote or maintain any religion. Okay, it means that whatever the secular administration and whatsoever the services the state is giving to the religious institution, against this the state will charge some fee. Thus a fee can be levied on the pilgrims to provide them some special service of the safety measures. Like if we talk about the Amarnath Yatra, okay, so we know that Amarnath Yatra has been the hostile zone of terrorism for long durations, right? So that's why whenever you have seen in the news channels and all, whenever the Amarnath Yatra organized, so there are always the deployment of CRPF personals. Okay, CRPF stands for the Central Reserve Police Force. Okay, so these CRPF personals have been deployed to the Amarnath Yatra. Okay, and these are for the safety and the service measures of the pilgrimages or the pilgrims who are going for the Amarnath Yatra. So basically the CRPF personals are coming under the Ministry of Home Affairs, right? And Ministry of Home Affairs is a part of the central government. So technically, if we look at here, so what we will find, we will see that basically the government is rendering its services. The government putting their security forces in the way so that the pilgrims who are going to the Amarnath Yatra, they will be safe and secure. So this is the rendering of services. For this, the government is entitled to charge fees. Okay, please do not get confused between the charging of fees and between the charging of taxes. Okay, they both are different. The fee is basically charging for providing the services, whereas you can see the another thing which is the taxes, they are charging for the practice of the religion. Similarly, a fee can be levied on the religious endowments for meeting the regulation expenditure. All right, after this we have the freedom from attending the religious instructions, and this is article 28 and last article of the right to religion. Under Article 28, no religious instruction shall be provided in any educational institutions wholly maintained out of the state funds. Okay? Remember this thing. What is the reason for it? Why? Because this will harm the secular nature of the government. However, this provision shall not apply to an educational institution which have been administered by the state but established under any endowment or trust requiring impartial or religious instructions in such institution. Like if we talk about the institution which was established and maintained wholly by the state funds, then no education could be provided. But if the institution was established by the trust, or you can say the religious endowment, but the state is only maintaining it, so the religious education up to some extent could be provided. Thereafter, further, no person attending any educational institutions recognized by the state or receiving aid out of state funds shall be required to attend any religious instructions or worship in that institution without his consent. Okay, it means that if we look at here, so what is written down here? No person attending any educational institution recognized by the state or receiving aid out of the state's fund shall be required to attend any instruction or worship in that institution without his consent. Okay, like you can say, if the person is not even attending the education institution, so the person could not be forced to attend the religious instructions and the worship in that particular institution if the person is not ready and haven't given his assent. All right, if that was recognized by the state or receiving aid out of the state funds. In case of a minor, the consent of his guardian is needed. Minor means below 18 years of age. Thus, the Article 28 distinguishes between the four types of educational institutions, okay, which we covered here. The first type is the institutions which are wholly maintained by the state, okay. Thereafter, the institutions administered by the state but established under the endowment or trust, the institutions which have been recognized by the state, and the institutions which are receiving aid from the state. So please keep these four types in your mind. First is wholly maintained by the state. Okay, let me give you. Wholly maintained by the state. Second, maintained by the state but established under any trust or endowments. Third, recognized by the state, okay. And fourth is receiving aid from the state, okay. So these are the four types of the education institutions. If we talk about the first, religious institutions are completely prohibited if the institution was fully maintained by the state. But if the institution administered by the state but established under any endowment or trust, so religious instructions are permitted. In C or D, it means that recognized by the state or receiving aid from the state, religious instruction is permitted but on a voluntary basis, not on a compulsory basis. It means if someone do not want to attend the religious instructions, the person is allowed to not attend it. All right. So students, basically in this lecture we have finished till here. In the next lecture we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.